Hi, I'm Russ Weninger. I'm a wills and estate planning lawyer in Calgary, Alberta, Canada. Today I'm going to talk to you about why you absolutely need a will, as well as an enduring power of attorney and a personal directive. I'm assuming you live in Canada, and more particularly in a part of Canada outside of Quebec. If you don't live in Canada, what I'm saying may still be applicable if you live in a common law jurisdiction. In other words, if you live in the UK or in a former British colony such as the US, Australia, New Zealand, etc., and your system of law is based on the English common law, then what I'm saying will likely have some applicability. I practice law in Alberta. From one Canadian province to the next, there can be a difference in what constitutes effective estate planning. But today I'm going to be discussing things that have fairly general applicability across Canada. In some countries, these estate planning documents may not be used, and legislation may govern what happens to your assets and who makes decisions for you in case you become mentally incompetent. But if you live in Canada, or the US, or the UK, or some former British colony, it's likely that you can benefit from having some or all of these documents prepared. Adults who are well shy of middle age and without dependents often have the view that a will is a discretionary item. You may have begun saving towards your retirement and may even have some life insurance. But for you, death is a long way away. And at any rate, maybe you don't have a lot of assets, or maybe even a negative net worth due to student loans and credit card debt. If that's the case, you may be tempted to think that a will is a luxury item and that it is entirely unnecessary at this stage in life. Think again. Let's forget the will for a moment and consider two other documents that are typically prepared at the same time that a will is prepared: the enduring power of attorney and the personal directive. In some places, the names of these documents might be different. Terms such as living will or medical directive or healthcare directive may be used. When I'm talking about an enduring power of attorney, I'm talking about a document that appoints someone as a representative to make financial decisions for you in case you become mentally incompetent. When I'm talking about a personal directive, I'm talking about a similar document that appoints someone to make medical and personal decisions for you in case you become mentally incompetent. In some cases, these documents may place constraints on the decisions your representative can make. While a will may protect your loved ones from financial hardship, an enduring power of attorney and personal directive are meant to protect you from things such as exploitation, abuse, and loss of dignity. You may take the position that your estate is not worth much at the moment, so a will is unnecessary. But if something were to happen to you that rendered you mentally incompetent, wouldn't you want the highest possible quality of life and the best possible personal representation? Yes, it's true that the likelihood of becoming mentally incompetent in your 20s or 30s is slim, but it is possible. A person at any stage of life can be rendered mentally incompetent due to a brain injury suffered in a work-related accident or in a car accident. While you can't prevent against every possible negative outcome, there are certain negative outcomes that you can take steps to prevent. Single people without children often have the mistaken view that they don't have to prepare estate planning documents because they don't have people who are dependent on them. As discussed a moment ago, single people without dependents still need the protection provided by enduring powers of attorney and personal directives. Married people, on the other hand, often have the view that they don't have to engage in estate planning, perhaps because everything is in joint names and their spouse will take care of them if something happens. But do you have children? If so, what will happen if you and your spouse both die, or if one of you dies and the other is rendered mentally incompetent, say due to a car accident? Who will be the guardian of your kids? Who will maintain a trust account for them until they reach adulthood? These scenarios are considered and dealt with in a will. If things aren't in joint names, a surviving spouse can be left with a tremendous headache. They may have to take time off work to grieve and to look after your children. If your bank account isn't in joint names and you die, the account will be frozen and your spouse may have to apply for a court order to have it unfrozen. It's typically not good enough if just one spouse has a will, enduring power of attorney, and personal directive. Even if one spouse has all the assets in their name and is the sole breadwinner in the family, the other spouse should still have a will, enduring power of attorney, and personal directive in case something happens to the first spouse. You are not protecting your spouse adequately, nor are you protecting your children adequately if you don't both have wills, enduring powers of attorney, and personal directives. Elderly people without assets sometimes assume that a verbal understanding that their children will take care of them is enough. But consider that some people will live on for years while suffering from dementia. If you're in that situation, your children will need legal documents to make medical and financial decisions for you. If you have not previously prepared an enduring power of attorney and personal directive, your children will encounter tremendous resistance when attempting to do your banking and pay your bills. And they may encounter resistance from doctors and nurses who are uncertain as to whether your children are authorized to make decisions for you. Even if you only have meager assets, having a will makes things much simpler for your loved ones. Even for things such as arranging a funeral, having a will can make things go much more smoothly. Please check out my upcoming video in which I will discuss the different roles, executor, guardian, and beneficiary, in a will. If you enjoyed this video, please feel free to like it, or share it, or subscribe to my channel. If you have a question, please leave it in the comment section and I will do my best to respond. While I don't want to give specific legal advice in the comment section, I will try my best to answer general questions, provided it is understood that my responses to comments should not be taken as legal advice, that social media interactions are not considered lawyer-client interactions, and that your safest course of action is to consult directly with me or another lawyer if you have a legal issue or would like to prepare a will.